Yes. Hello, everyone. Uh, I think we are still waiting for more people to join. So let's wait a couple of minutes more to allow everyone and kick off our meeting. Thank you. Okay, I think we can kick off, and if more people will come, they can pick it up. Welcome everyone, firstly, and thank you for joining today's discussion. I saw most of the attendees are Turkish, but it's actually this webinar is intended for the English-speaking people. Of course, Turkish-speaking people are also welcome, but we'll have our discussion in English. And so, okay, it's Turkish merge control regime has been very active in the last couple of years, and this year also witnessed very important changes in February 2026. And we just wanted to capture these amendments with a general overview of the Turkish control regime, and would like to share some practical guidance on how to tackle Turkish merge control rules for transactions, merger and acquisition transactions, and we'll start our discussion with general information on the notification obligation under Turkish merger control regime, and we'll provide some information on the notification timeline and the context of the notification form. And I think one of the most important things that we'll talk about will be standstill obligation and gun jumping regime under Turkish competition law, as it would have serious consequences as in administrative monetary fines. And we'll finish with some key considerations and what to do or not to do. So, notification obligation under Turkish merger control regime actually lies with Communique number 2010/4 on mergers and acquisitions requiring the approval of the competition board, which is the secondary legislation coming after the main legislation, which is law no 4054 on protection on competition. And the Turkish merger control regime rules are mostly stipulated under this communique. So this is a very simple display that you're seeing, which is the notification obligations simple table. So we should first examine that. Is there a change in control on a lasting basis in consequence of the transaction and the jurisdictional turnover thresholds exceeded? If these criteria are met cumulatively, we should notify our transaction to the Turkish Competition Authority, and the Turkish Competition Authority should approve the transaction before the closing by way of applying the SIEC test, which is the significant impediment to effective competition test, which is very similar to EU regime. And a quick look at what constitutes a merger and acquisition, which would be defined as the transactions that result in a lasting change of control. And if there's a lasting change of control and the jurisdictional thresholds are exceeded, a notification obligation would arise automatically under the Turkish merger control regime. And when you already know about the basics of the Turkish merger control regime, I'm sure, and without getting into much detail, I just wanted to highlight some key considerations and some practical points that might sometimes might not get caught from the eye, and we should talk about, and you should know. So we have mergers and acquisitions in theory and in principle, but joint venture transaction would also be subject to Turkish merger control regime, and they are qualified as acquisition transactions under the communique, merger control communique. And joint venture transactions should be a full function, should create a full function joint venture, and the joint control should also be acquired on a lasting basis for the joint venture transactions. And most importantly, I think foreign-to-foreign transactions are also subject to the review of the Turkish Competition Board under the Turkish merger control regime, as there is no Turkish nexus test, or there is no affected market criteria under the Turkish merger control regime. And as long as there is a change of control and the jurisdictional thresholds are exceeded, the notification obligation will be triggered, and a compulsory notification should be made to the Turkish Competition Authority. Let's talk about a little on control, how control would be defined under the Turkish merger control regime. The control definition is also very akin to EU regime, and would refer to rights, contracts, or other means which confer the ability of exercising decisive influence over an undertaking. The key point on this is that it's not the exercising itself the decisive influence, but the ability of it. So when an acquirer would have the ability, just the ability to exercise decisive influence, that would suffice for the purposes of control. And when we think about some examples on the means conferring control, control may be established de facto or de jure, and it's not necessary to have some kind of contract or some kind of share transfer to confer control on a target's undertaking, and de facto control would also be considered as the means conferring control. And as for the jurisdictional turnover thresholds, as I mentioned, there are very important amendments to the Turkish merger control regime, which were introduced in February 2026. And these amendments also included the increase in turnover thresholds, and this increase was very, very important, and it was nearly 3-4 times more than the former threshold, which were introduced 4 years ago. And in 4 years, the turnover thresholds have been increased significantly. So as you can see, the aggregate turnover of the transaction parties have been increased from 750 million to 3 billion Turkish liras, and individual turnover thresholds have been increased to 1 billion Turkish lira, which is close to 20 million euros. And these thresholds, this increase in the turnover thresholds, are intended to lower the Turkish Competition Authority's workloads on mergers and acquisitions, and their they want to focus on investigations and also legislative works they want to focus on. And we also have the technology undertaking exception. Most of you would know that this technology undertaking exception was first introduced in 2022 amendments again. And when it was first introduced, it was kind of vague, and application of this exception raised some questions in practice, and the Turkish Competition Board decisions on this technology undertaking exception were also not the same direction. All decisions were not the same directions, and in this recent amendments, there were some clarifications on technology undertaking exception as well. So when we remember the technology undertaking the definition, undertakings operating in the fields of digital platforms, software and gaming software, financial technologies, biotechnology, pharma technology, agricultural, chemicals, and health technologies would be defined as technology undertaking under the Turkish merger control regime. And before the recent amendments, in such transactions where technology undertaking is targets and operate in the Turkish geographic market, or conduct R&D activities, or provide services to users in Turkey, the turnover threshold for the target company would not be applicable at all for such transactions, and basically all transactions where such a technology undertaking is a target would be notifiable to the Turkish Competition Authority. So this exception, as its past version, had a lot of ambiguities, and the workloads of the Turkish Competition Authority were very increased by such a expanded exception. And with the new amendments, the technology undertake exception, let's say, was limited to the technology undertakings established in Turkey. Before that, establishment was not a criterion for this exception to be applied, but with the new amendments, such undertakings must be established in Turkey. And also, we now apply the thresholds as a lower threshold, which was the previous target threshold of 250 million Turkish liras instead of 1 billion now. So let's check the notification timeline and the notification form itself. We have a little diagram here to capture the general picture of a notification process. We would start with the preparation and submission of the Turkish filing, and the Turkish filing can be submitted by acquired by the seller or by both parties as a joint filing. So there is no obligation on the party that would do the filing, and also there is no filing fee before the Turkish Competition Authority. And within the filing, we should provide the authority with the translation of the transaction agreements, but it's useful to note that such transaction agreements would not to be in their final forms to have the submission filed to the Turkish Competition Authority. So Turkish Competition Authority would accept filings with the most recent forms of the transaction agreements, as long as the key points and key commercial terms of the agreements are already visible from the current versions of the transaction agreements. So after the filing of the transaction and assuming a straightforward transaction with no or low competition law concerns, the review of the Turkish Competition Authority will take around 8 to 12 weeks. This review process would most probably include a couple of rounds of RFIs, requests for information, from the case centers, as the 30 calendar day review periods in most of the case would be accessed by the review of the case centers, and with the issuance of official RFIs, such 30 calendar day review periods would be cut, and with the submission of the responses to the RFI, the review period would start from day one. And following the approval decision of the competition board, and after obtaining the short form approval decision of the competition board, the transaction is cleared to be closed. And as far as Turkey is concerned, the parties are free to close the transaction with the short form decision of the board approving the transaction. When we talk about the context of the notification form, you can see the headings of the sections of the notification form, which would be summarized as information on transaction, information on the parties, information on the relevant markets, as far as is applicable, the joint ventures, and the contact details of the parties and the representatives. So with the new amendments, there were also some changes in the notification form. Notification form were amended in 2022 again with the previous significant amendments in the Turkish merger control regime, and we can say that the notification form was amended again to more reflect the notification form before the 2022 changes. So before the changes in 2022, we had affected market share thresholds for the affected markets, vertical and horizontal affected markets in the transaction, and in cases where the parties' market shares would not reach certain levels of market share, we can skip some information to provide, and we can have so-called short form notification form to have an expedited process. So in the current form, we have 15% of market shares in horizontal affected markets and 20% market share threshold for the vertically affected markets, for some information, for some detailed information not to be provided by the parties, and to allow expedited and more simplified procedure in the review of the transaction and the notification form. And this amendment, as I mentioned before, aims to reduce the administrative burden on notifying parties and facilitate a more efficient review process. So I think the most important parts would be the standstill obligation and gun jumping risks under Turkish merger control regime, because, as I mentioned, foreign-to-foreign transaction would also be caught under the Turkish merger control regime, and it's very important to look out for the Turkish regime as well when the International Council run multi-jurisdictional filings, because Turkey has a very rigid regime on merger control, and it's very important to be aware of the notification obligation in Turkey, and also the gun jumping risk would be evaluated very diligently. Indeed, the implementation of a notifiable transaction in Turkey is suspended until clearance by the competition board is obtained, and a notifiable transaction would not be legally valid or be closed in Turkey prior to the board's approval. And when or if, let's say, the board becomes aware if the transaction would be closed before the approval, and somehow the authority would become aware of this situation, it would initiate an examination and assess whether the transaction significantly impedes effective competition. And pursuant to Article 16 of Law number 4054, violation of the suspension requirements, meaning that if the transaction would be closed without the approval decision of the board, and turnover-based administrative monetary fine would be imposed on the acquiring undertaking with the amount of 0.1% of the Turkish turnover generating in the financial year preceding the date of the fining decision. And this fining decision is can be said that it's automatic, and there is no discretion of the board to impose such an administrative fine. So when the board or the authority would find out that the transaction is a notifiable transaction is closed before the approval, this monetary fine would automatically be imposed on the incumbent parties. And if such transaction, such notifiable transaction would impose competitive concerns, and if the board following their assessment would say that the transaction would create competition concerns, the administrative monetary fine would even be higher, and the transaction parties would face very serious administrative fines in case of a competitive concern transaction. So to talk about how to identify gun jumping, we would like to share a recent decision where the board examined a gun jumping case. It's called Param Kartik decision, and in the transaction concerning Param's acquisition of sole control over Kartik, the board examined whether de facto control had been obtained without prior approval. Findings of the board included some indicators of de facto control, and the board stated that even the de jure control, meaning that the closing of the transaction had not been completed before the approval of the board, de facto control have already been transferred to the acquirer with the evidence including appointment of senior management, influence over promotions and salary increases, joint marketing and sales activities, intervention in day-to-day operations, and provision of human resources support, and an administrative fine corresponding to 0.1% of the acquiring party's turnover in Turkey was imposed following the decision. So the decision, this decision is an important one and is an illustrative one, we can say, as the board explicitly states the indicators of de facto control and clearly indicates that the transfer of de facto control would be enough to lead to the change of control. And it's important that important for the parties that before the closing of the transaction, there should not be any activities that would confer transfer of control before the approval. And with this overview, after this overview, we would like to share some key considerations in practice that the parties would need to be careful on. And let's start with the key changes introduced by the recent amendments. As I mentioned, the February amendments were actually very important, and the Turkish merger control regime has been introduced with new rules with the amendments. So with these amendments included changes in the merge control communique, and the regime applicable to technology undertakings has been clarified, and the vague nature of technology undertaking exception has been improved, we can say, with the new amendments. And some core definitions follow these amendments in different parts of the communique. And the substantive assessment framework for mergers and acquisitions have been clarified with the new changes. And also, as I also mentioned, notification form witnessed important changes, and we can say that the notification form has been amended to have a more compact notification form. Actually, the previous version of the notification form that we used for nearly 4 years included information requests that weren't really necessary for the assessment of a no competition concern transaction, as even in de minimis overlapping transactions, the transaction parties would need to provide very detailed information on, for example, import conditions or efficiency gains. And with the new amendments, notification form has also been simplified, and we have a more compact and more streamlined notification form, we can say. And the new amendments also clarified the assessment of joint ventures and the coordination risks of the joint ventures have been more clearly explained under the new amendments. And lastly, the information requested from private equities or venture capitals were also simplified under notification form. And now when we have an acquirer, which is a private equity, for example, the global activities of such private equities were not sought in the notification form now, and the Turkish activities of the private equities would be sufficient to be provided by the parties. In line with the changes under the merge control communique, very recently, I think last week or the beginning of this week, the relevant guidelines of the Turkish Competition Authority were also revised to reflect the amendments in the merger control communique, and the guidelines on cases considered as mergers and acquisitions and the concept of control clarified the transactions, creeping transactions, which are transactions carried out within a 3-year period, maybe treated as a single transaction, including in the context of joint ventures. It was not explicitly provided before that the joint ventures would also be included in the contents of this rule before, and this was clarified. And the guidelines on the relevant undertaking turnover and ancillary restraints in mergers and acquisitions were also updated in line with the merge control communique, and particularly regarding transaction party definitions, turnover calculations, technology undertakings, and again, 3-year rule for multiple transactions. Lastly, the guidelines on the assessment of horizontal mergers and acquisitions and the guidelines on the assessment of non-horizontal mergers and acquisitions introduced additional explanations regarding the assessment of coordination risks between parent companies in joint venture transactions, as also mentioned again. So lastly, I like to share some key considerations in practice that legal counsel, external counsel, or the relevant teams in companies should be aware of, and they are very important. So transactions resulting in change of control on a lasting basis shall be notified and approved by the competition board if the jurisdictional turnover thresholds are met. We received the question most of the time that if there is an exception on the notification obligation, or we have no Turkish nexus in the transaction, and if it will be okay not to notify the transaction, the answer is simply no. And as we laid down here, as long as there's a change of control and as long as the Turkish jurisdictional thresholds are exceeded, there is a notification obligation in Turkey. And in case of not notifying the transaction and closing the transaction without the approval of the board, there will be administrative monetary fines to be imposed on the incumbent undertakings under the gun jumping rules of the Turkish merger control regime. And notification may be submitted based on sufficiently mature draft agreements even before transaction documents are formally executed. So there is no specific deadline for the transaction to be notified to the Turkish Competition Authority, but the deadline that we should be aware of is that the closing deadline, that without the approval that should not be proceeded. So if there is a time restraints and the closing would be conducted in a short period of time, we would not need to wait for transaction agreement to be executed, and we can proceed with the notification by way of submitting the recent versions of the transaction agreements. And transaction shall not be closed before, as I repeated most of the time, maybe a little bit much more, but it's very important that the transaction shall not be closed before obtaining the competition board's approval, and the standstill obligation must be strictly observed. As this is very important because the administrative monetary fine is an automatic one and there is no discretion of the board. And when the board would be aware of such a violation of the standstill obligation, the administrative fine is automatically imposed on the relevant parties. During the interim period, parties must act cautiously and avoid sharing competitively sensitive information. So before the approval of the board and, of course, closing of the transactions, when we assume a horizontal transaction, the parties are still competitors in the relevant market, and general competition rules are applicable to such parties. So the competition board actually is aware of the fact that there would be some preparatory steps toward the closing, and there should be some procedures to be followed before the closing. But when such procedures are followed, the parties should be very cautious of the risks that the transaction, that the competition law infringements would be faced by the parties. And lastly, but importantly, the competition board may request additional information during the review process, and timely responses are critical, as each information request may effectively restart the review timeline. So under the general Turkish competition law rules, the authority of the Turkish Competition Authority on information requests is very broad, we can say, and authority is able to request information from the parties and also from the third parties as well. So it's very important to actively cooperate with the authority in such review processes or other processes that we will face. And timely responses are critical because the review period that I talked about, the 30 calendar day review period, would restart with the submission of the responses. So without the submission of the responses, the review period would not restart, and there would be some delays in the transaction timeline. So this is all I want to talk about today. I hope it was useful for you to have some practical information on Turkish merger control regime, as most of the time we experienced that Turkish rules in multi-jurisdictional filings, sometimes the Turkey would not be, let's say, would not be the jurisdiction, one of the jurisdictions that the International Council would not see as an important jurisdiction, but Turkish rules are very strict, and there are serious consequences in case of not complying with the Turkish merger control rules. So thank you everyone taking the time for today's session, and I would be happy to answer any questions that you may have or discuss with you any comments that you might have. Okay, I think this was all for the attendees as well. I know it's getting late and you want to go home quickly. But you can reach out anytime if you have questions on Turkish merger control or related competition law matters on Turkish law. So please feel free to reach out in any means, by mail, via LinkedIn. And thank you again for your time of today. Goodbye.